Hello and welcome to Courts This Week. I'm Dina Osha. In this special edition, we bring you top stories of legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we'll also inform and update you of all the important proceedings from the week. So let's start Courts This Week. Putting to an end the jurisdictional tussle between the Bihar police and the Mumbai police, the Supreme Court held that the Central Bureau of Investigation's probe into the FIR lodged against actress Riya Chakravarti in connection with the death of Sushant Singh Rajput is lawful. The court had further directed the Mumbai police to hand over all the evidence in the case to the CBI. The judgment was passed by a single judge bench of Justice Hrishikesh Roy. The court also directed the CBI to look into any other cases registered in the future in relation to the death of Rajput. The Maharashtra government has been ordered to assist the CBI in the investigation. In deciding the matter, Supreme Court has invoked Article 142 to decide the matter. Validity of Section 406 was also addressed.
The Supreme Court has upheld the Bihar government's order to transfer the probe in the case related to the death of actor Sushant Singh Rajput to CBI. A single bench of Justice Hrishikesh Roy held that Bihar police had jurisdiction to register FIR with respect to death of Sushant Singh Rajput at the complaint of the actor's father and held the transfer to CBI valid. The court has directed Maharashtra police to hand over the case files to CBI and to render necessary assistance.
ये आज बड़ी भारी विक्ट्री है सुशांत सिंह के परिवार के लिए। ये एक लड़ाई हम लड़ रहे हैं 2 महीने से ज़्यादा से सुशांत को जस्टिस दिलाने के लिए, उनके परिवार को जस्टिस दिलाने के लिए। और इतने अड़चने आ रही थी, इतने बाधाएं पड़ रही थी। मुंबई पुलिस ने इसको दिशा बिल्कुल गलत दिशा दे रखा था। और आज सुप्रीम कोर्ट ने बड़ा स्पष्ट शब्दों में कह दिया है कि मुंबई पुलिस ने जो भी इन्वेस्टिगेशन किया उसका बड़ा लिमिटेड दायरा था, उसमें कोई इन्वेस्टिगेशन नहीं था। कोर्ट ने यह भी कह दिया है कि पटना पुलिस में एफआईआर रजिस्टर करने की अब बिल्कुल जुरिस्डिक्शन था। कोर्ट ने यह भी कह दिया है कि बिहार सरकार सीबीआई को रेफर कर सकता था मामले को। लेकिन इन सब के बावजूद कोर्ट ने सबसे बड़ी बात यह कह दी है कि इस सीबीआई इन्वेस्टिगेशन को हम अपने कोर्ट का भी स्टैंप दे रहे हैं और कोर्ट की तरफ से भी कह रहे हैं कि ये सीबीआई से ही होनी चाहिए।
The court, while invoking its plenary jurisdiction under Article 142 of the Constitution, has held that if any other case is registered on the death of actor Sushant Singh Rajput and the surrounding circumstances of his unnatural death, the CBI is directed to investigate the new case as well. Justice Hrishikesh Roy held that a fair, competent and impartial investigation is the need of the hour. The court also held that any future FIR which is likely to be registered by the Mumbai police in furtherance of its inquiry process under Section 174 CRPC should also be investigated by the CBI. Court, while taking note of both states are making acrimonious allegation of political interference against each other, has observed that the legitimacy of the investigation has come under a cloud. While holding that the incidents referred to in the complaint indicate that the Mumbai police possesses the jurisdiction to undertake investigation on those circumstances, therefore, in the event of a case being registered in Mumbai, the consent of the investigation by the CBI under Section 6 of the Delhi Special Police Establishment DPSE Act can be competently given by Maharashtra government. One of the issues considered by the court in this case was whether the Supreme Court has power to transfer investigation, not case or appeal, under Section 406 of the CRPC. To answer this issue, the judge referred to the decision in Ramchandra Singh Sagar versus State of Tamil Nadu in 1978, in which it was held that the power under Section 406 CRPC does not clothe the court with the power to transfer investigation from one police station to another in the country simply because the first information or a remand reported is forwarded to a court. A single bench of Justice Hrishikesh Roy had reserved order after hearing Chakravarti, Bihar government, Maharashtra government, Central Bureau of Investigation and Rajput father on 11th of August. Rajput, aged 34, was found dead in suburban Bandra in Mumbai on 14th of June. Bureau report.
Lawyer activist Prashant Bhushan held guilty of contempt for his tweets on Chief Justice of India S.A. Bobde, and the Supreme Court told the top court that he was pained at being grossly misunderstood and that he considered his tweets as an attempt to discharge his highest duty. After a sharp back and forth over whether his tweets have crossed the line, the Supreme Court gave Bhushan 3 days to consider his statement. The Supreme Court rejected the submissions of the Prashant Bhushan that the arguments on the quantum of sentence in the contempt proceedings in which he has been held guilty will be heard by another top court bench. A bench headed by Justice Arun Mishra gave assurance to Bhushan that no punishment will be acted upon till his review against the order convincing him of the case will be decided.
In its suo motu contempt case initiated against advocate Prashant Bhushan, the Supreme Court has given the lawyer 2 to 3 days time to reconsider his statement on the proceedings. Quite significantly, Attorney General for India K.K. Venugopal urged the court not to proceed against Bhushan during hearing on sentencing. In his statement, filed in response to 14th August verdict holding him guilty of contempt, Bhushan paraphrased the words of Mahatma Gandhi saying, "I do not ask for mercy. I do not appeal to magnanimity. I am here, therefore, to cheerfully submit to any penalty that can lawfully be inflicted upon me for what the court has determined to be an offence and what appears to me to be the highest duty of a citizen." The order was passed by the bench of Justice Arun Mishra, B.R. Gavai and Krishna Murari, which had found Bhushan guilty of contempt of court for his tweets criticizing Chief Justice of India S.A. Bobde, and the judiciary posted earlier this year. Nothing that the review petition was yet to be filed, Justice Gavai suggested that it appears that the review will be sought when one of the judges on the bench, Justice Mishra, has retired. Justice Mishra retires on 2nd of September. The bench made it clear that it would not defer the hearing. Senior advocate Rajiv Dhawan then said he was not in the favor of deferment of the hearing. At this point, Bhushan read out his statement in response to the Supreme Court's verdict finding him guilty of contempt. The statement reads, "I am pained at the verdict that the court held me guilty. I am pained that I am grossly misunderstood. I am shocked that the court arrived at the conclusion without providing any evidence about my motives. I believe that open criticism is necessary in any democracy to safeguard the constitutional order. Saving the constitutional order should come above personal or professional interest. My tweets were a small attempt to discharge what I consider my highest duty. I do not ask for mercy. I do not appeal for magnanimity. I cheerfully submit to any punishment that court may impose," Bhushan added. "My tweets were out of a bona fide attempt to discharge my duty as a citizen. I would have been failing in my duty if I did not speak up at the juncture of history. I submit to any penalty which the court may inflict. It would be contemptuous on my part to offer apology." Dhawan then addressed the court, arguing that in contempt cases, the nature of the contemptor as well as the nature of the offence have to be considered. The bench then sought Attorney General K.K. Venugopal's view on the statement made by Bhushan and whether he should be given more time. In response, Attorney General Venugopal said that it would be tremendously good if Bhushan is given some time. The court ultimately gave Bhushan 2 to 3 days to reconsider his statement made in response to the August 14th verdict. On 14th August, the court had convicted Bhushan for contempt of court and fixed the date of hearing for his sentencing on 20th August. Bureau report.
The Supreme Court has reprimanded Centre for not releasing stress fund money in the Amrapali builder case. During the hearing, Centre told that there is supervisory issue between the SBI, CAP and the NBCC. The apex court said that we are concerned and if matters are not sorted out, we will invoke Article 142. The Supreme Court has pulled up the central government for not releasing money from the real estate stress fund created by them towards completion of the Amrapali projects, despite being asked to do so repeatedly over the last 3 months. The bench, comprising of Justices Arun Mishra and U. Lalit, asked Solicitor General Tushar Mehta why money from the rupees 20,000 crore fund was not being moved by the government. This came after senior advocate Harish Salve, representing SBI Capital, informed court that there were certain issues that were creating an obstacle in finalizing SBI Cap's final proposal to finance the project. Salve mentioned that one of the problems was supervisory issues between the SBI Cap and the NBCC, and that the latter was reluctant to become a party to a fixed-term contract. On this, Justice Mishra said that, "We are concerned about what is happening between SBI and NBCC. We will use our power under Section 142 if needed unless you work out a solution to this problem." Having noted Salve's submission, however, the court granted SBI Cap time to sort out the issues. The court has also clarified that dispersal of the payment by SBI should not be target-oriented with respect to NBCC. Supreme Court also asked the SBI Cap to consider the rates of interest at MCLR rates, having opined that the current rates was not justified. Thus, on the aspects of bank financing, the court orders as follows. They have prayed for time as there was only certain aspects which remain to be creased out, and they are likely to be sorted out, including the issue of rate of interest, supervisory issue between the NBCC and SBI Cap, and stage of the funding, whether it is to be target-oriented by the next date of hearing. Dispersal to be made by the SBI Cap should not be target-oriented. Let all this aspect be worked out by the next date of hearing. Allowing the prayers to find out the feasibility of formations of consortium of banks which can extend finance to the various projects based on the unsold inventories and securities. The court ordered that the committee as well as the receiver are permitted to work out details and place the same before this court. Justice Mishra allowed the committee to evaluate the projects correctly and then auction the same through MSTC. With regard to the IMT Manesar property, the court permitted the following three proposals made by the receiver: to demand a payment of dues as ascertained by auditors from the allottees who are in possession of units, registration of allottees, sale of those units which are not occupied through MSTC. The court was informed by the Corporation Bank and the UCO Bank that a new MOU had been sent to the court receiver. The court directed the receiver to consider the MOU and report back while allowing home buyers to avail of loans as proposed by the banks. Let the receiver look into the MOU and reports back to this court on the next date of hearing. In the meantime, home buyers who want to avail the loan facility as proposed by the UCO Bank and Corporation Bank are free to do so. Let the concerned branches disperse the loan to them as per the MOU. The court also allowed the central government request to be given access to the forensic auditor's report in relation to all Amrapali companies, its subsidiaries, and shell companies in order to scrutinize and investigate the extent of the tax evasion. The matter will again be taken up for considerations on August 19, 2020. Bureau Report. The Supreme Court has dismissed an application which sought the disbanding of the Justice retired B.S. Chauhan Inquiry Commission constituted to probe the alleged encounter of the UP gangster Vikas Dubey. The bench of Chief Justice S.A. Bobde, Justice A.S. Bopana and V. Subramaniam said, "We have provided some safeguards in the manner in which the probe is to be conducted. The plea has no merit and is accordingly dismissed. The application has alleged that the fraud of the high magnitude practiced upon the court by all stakeholders responsible for appointing Justice B.S. Chauhan, Sashikant Agarwal, K.L. Gupta and Ravinder Gaur on the Judicial Commission. When the matter had come up for the hearing, the bench headed by CJI S.A. Bobde pulled up the petitioner for filing such a plea, casting aspersions on member of a court-appointed commission, including a judge, especially on the basis of a media report. The names of the committee members were proposed by the Uttar Pradesh government.
The Supreme Court has dismissed a plea file seeking to disband the three-member inquiry commission headed by retired Justice B.S. Chauhan, which has been tasked to investigate the extrajudicial killing of gangster Vikas Dubey by the Uttar Pradesh police. The petitioner had expressed apprehensions of bias citing political link of member of Justice Chauhan family. The bench of CJI S.A. Bobde with Justice A.S. Bopanna and V. Ramasubramaniam today found no merit in this plea and dismissed the same, observing that the court is providing for certain safeguard with which the inquiry had to be conducted. When the matter had come up for hearing, the bench headed by CJI S.A. Bobde pulled up the petitioner for filing such a plea, casting aspersions on member of court-appointed commission, including a judge, especially on basis of a media report. During the hearing in the case as well, the court had remarked that bias cannot be assumed merely because Justice Chauhan family member are political leader associated with the party in power. The other member of commission are retired Justice Shashikant Agarwal and former Uttar Pradesh DGP KL Gupta. Petitioner Upadhyay had earlier also sought the ouster of Gupta from the inquiry committee for allegedly making statement prejudicial to the inquiry. The plea too was dismissed by the Supreme Court. This inquiry committee was set up by the state of Uttar Pradesh and approved by the Supreme Court to look into the alleged fake encounter in which gangster Vikas Dubey was killed earlier this year. The commission was directed to submit its report in 2 months' time on 22nd July. The order was passed on plea seeking a probe into the extrajudicial killing of gangster Vikas Dubey. The Supreme Court had earlier sought a draft notification from the state of Uttar Pradesh with a view to reconstituting the panel probing the killing of gangster Vikas Dubey. The CJI-led bench had asked that the retired Supreme Court judge and former high-ranking police official be included in the commission, along with the retired High Court judge already proposed, so that the probe can be impartial and thorough. Bureau Report.
The Supreme Court has rejected a petition by an NGO seeking transfer of the contributions in the PM CARES Fund to National Disaster Response Fund. The NDRF is a statutory fund created under Section 46 of the Disaster Management Act 2005. The court held that individuals and organizations are free to contribute to NDRF and there is no prohibition on the same. However, PM CARES is a separate fund established as a public charitable trust and no directions can be issued to transfer funds from that to NDRF. A 3-judge bench headed by Justice Ashok Bhushan ruled. While disposing of the petition, the court said that there is no need of the fresh National Disaster Relief Plan. The NGO Center for Public Interest Litigations has claimed that PM CARES Fund was set up in the violations of the legal mandate under the Disaster Management Act, as per which any grant made by any person or institutions for the purpose of disaster management should be compulsorily credited to NDRF. The PM CARES Fund was set up by the central government on March 28 as a public charitable trust with the primary objective of dealing with any kind of emergency or distressed situations such that posed by the COVID-19 pandemic. The central government had rebutted this argument, stating in its affidavit before the top court on July 8 that the PM CARES is a fund established to carry out relief work and there are several such funds established on similar lines in the past. During the hearing before the Apex Court, the central government through Solicitor General Tushar Mehta had defended the PM CARES Fund, saying that it was not intended to circumvent the NDRF as alleged by the petitioners. The Supreme Court has granted a limited relief with respect to the registration of the BS4 vehicles. The court said that there are still stated to be a large number of sales which have been made and uploaded on the e-Vahan portal. Even temporary registrations were made. Their registration during the lockdown period could not be made. Hence, we allow registration of such vehicles only which could not be registered during lockdown in the month of March 2020 and no other reasons, ordered a bench comprising Justices Arun Mishra, B.R. Gawai and Krishna Murari. Furthermore, the Supreme Court went on to clarify in no uncertain terms that the order for allowing registration applied to the entire country but not Delhi NCR. It has been categorically laid down that there will be absolutely no registration of BS4 vehicles in Delhi NCR post-March 31, 2020. However, the position of the Delhi and NCR is different. We clarify our order dated 27 March 2020 to the effect that no registration of BS4 vehicles is to be made in Delhi and NCR as people are suffering from severe air pollution, and the order passed by this court in 2018 was clear. No vehicle of the BS4 in Delhi and NCR to be registered. During the hearing on August 13, Additional Solicitor General Aishwarya Bhati informed court that details of 39,000 vehicles had not been uploaded. But besides that, rest of the vehicles have been traced and the details were unavailable on the eVahan portal. Appearing on behalf of the Federations of the Automobiles Dealers Association, Senior Advocate KV Vishwanathan sought registration of vehicles that have been sold till May 31, citing losses to the dealers. He also appraised the court of the trouble faced by certain purchasers who had booked the vehicles online but could not register the same during the lockdown period or had not taken delivery of the vehicles. With regards to the sales of the vehicles during lockdown, Justice Mishra was stern with regards to the compliance of the previous court orders, according to which sales would only be allowed till March 31, 2020. With the lockdown coming into play effectively, only those sales that were made prior to March 25 would be considered. The Punjab and Haryana High Court has asked its Registrar General to circulate to all the presiding officers designated courts dealing with cases of crime against women in the state of Punjab, Haryana and the Union Territory Chandigarh its observations against lewd, filthy and indecent questions put to the prosecutrix in a rape case, which the court said could not have been allowed by the trial court. Justice Arvind Singh Sangwan added that such conduct is in violations of the directions given by the Supreme Court in State of Punjab versus Gurmeet Singh 1996, where the top court stipulated that while conducting the cross-examination of victims of sexual assault, the court should be vigilant that defense counsel should not adopt a strategy of continuing questioning the prosecutrix to the detail of the rape. Also, the court should not sit as a silent spectator while the victim of the crime is being cross-examined by the defense, and it should effectively control the recording of the evidence to avoid her victimizations. The single judge was hearing a set of appeals emerging out of the same judgment of convictions and order of sentence passed by the trial court in a rape case. While every latitude should be given to the accused to test the veracity of the prosecutrix and the credibility of her version through cross-examination, the court must also ensure that cross-examination is not made a means of harassment or causing humiliation to the victim of crime. A victim of rape, it must be remembered, has already undergone a traumatic experience, and if she is made to repeat again and again, it's unfair, unfamiliar surrounding what she has been subjected to. She may be too ashamed and even nervous or confused to speak, and her silence or confused stray sentence may be wrongly interpreted as discrepancies and contradictions in her evidence. Well, that's all in courts this week. Thank you so much for tuning in. Keep watching APN and stay safe.